Hi, I'm Robert Chisholm, founding partner of Chisholm, and Kilpatrick. I'm here with Zach Stolz, a partner here at the firm. The Court of Appeals for Veterans Claims just decided an interesting case. We thought we'd discuss it for you, not just because of the impact that it will have on veterans, but so you can get some insight into how a VA accredited law firm adapts constantly to what's happening every day in veterans law. So Zach, tell us what happened in the Williams versus McDonough case.
Thanks, Robert. Well, Mr. Williams filed an appeal to the Board of Veterans' Appeals in June of 2021. Before his time expired to elect a switch in BVA dockets, the board made a decision on his case and off of his notice of disagreement. Mr. Williams then appealed to the court, in part based on his grievance that the board cut short his window to switch dockets at the board. As a side note here, anybody who has a claim at the Board of Veterans' Appeals can switch dockets within a 1-year period of the underlying rating decision, or 60 days after filing of a notice of disagreement, whichever date is later. Long story short on that, veterans are given a choice at the board to be able to move their case as they see fit, hopefully to get a quicker decision or to submit some evidence if they need to, or whatever they need to do at the Board of Veterans' Appeals. And they're given a year to do so. In this case, the board made a decision before that year time period lapsed. So they appealed to the Court of Appeals for Veterans Claims, and that court agreed with Mr. Williams and his advocate, and they decided that the board cannot issue a decision until the time to modify a notice of disagreement has run.
Sounds a little complicated, but what are the implications of this for veterans?
So at first glance, Robert, seems like a really good, an unequivocal good thing for veterans, right? The VA has a regulation saying that that veterans have a year to kind of figure out what they want to do when they're at the Board of Veterans' Appeals. And BVA can't just cut short that window and not give you the time that you may need to make that decision. But it's a mixed bag because, as people who are familiar with our website know and are familiar with my work in particular know, we are very hard on the board for the delays in that system and how long it takes. And so expecting veterans to wait a year after they get to the board, in addition to the already 3 to 4 years that they have to wait, can be a bad thing. So while it is good that veterans are being given this fair process and this due process, and while I do agree, frankly, with the court's decision, it correctly interpreted the law, it's not always a great thing for veterans, especially people who are maybe a little bit elderly or sick or really having financial hardship. We're not going to want the board to wait that whole year. And that really goes to why an experienced counsel is so necessary at the Board of Veterans' Appeals, because we need to be able to discuss with our clients what best suits them and hopefully be able to waive this year's requirement if necessary in order to get those decisions to go faster. So it's good and it's bad. It's the right decision on the law, but we do need to be careful that this year doesn't add undue hardship on so many veterans that are already waiting such a long time in this process.
So let's pause there for a moment because I do want to pick up on this issue of waiver. Are we sure that you could waive that period that the court has now said is in this regulation by VA?
Robert, I'm 100% sure that you can. But that doesn't mean the Board of Veterans' Appeals is going to listen to us. So we are working on this. We're going to try to. I will tell you that in my experience and with what I believe to be true, the board absolutely can waive these. Whether they will or not remains to be seen. If they don't, we're going to fight them because they do need to waive this. This is something that with the full good knowledge, veterans and their representatives should be able to waive this time period if they want to. Veterans should be entitled to have the year if they need it, but if they don't want it, we should be able to waive it and keep moving this very long line forward so that veterans can get the benefits to which they are entitled.
So I think I know the answer to this next question, but what can veterans and representatives do in this situation?
Talk it through. First of all, make sure that veterans are comfortable with where they are and what is going on in their case at the board, and then trust experienced advocates to guide them through this process and have one. Have somebody, have an accredited person in particular from a veteran service organization like DAV or us at CCK or anyone who is experienced in this field because you may not want to wait that year, and you're going to really want to know. In the Appeals Modernization Act, veterans claims, I will tell you, have gotten more complicated, not less complicated. And so talking this through, being comfortable with what your advocate wants to do, and knowing what your rights are, imperative in this process.
So what are we doing here at CCK for our clients given this recent case decision?
We're going to be using a lot of waivers. For every client, we are going to be waiving any remaining time that our client does not need to modify this notice of disagreement or to switch dockets. We're making updates throughout our processes to waive any unnecessary periods that would delay, and we are urging VA to make a decision as promptly as possible. So again, while we appreciate what the court did here, and while we certainly congratulate the veteran and his advocate for good advocacy at the court, and it shows the importance of the court in this process, this is not necessary in a lot of cases, and with good advocacy, we are going to be asking not to wait that year.
Zach, let's take a step back for a moment. Why is the court so important? Isn't veterans law really about VA administrative processes? And what's the benefit of having court-ready representation?
Well, the court is a vital part of this process because before the court existed, it was called splendid isolation, which is VA was accountable really to no one. The department could really interpret its regulations however it wanted, interpret statutes however it wanted, and the court now exists to really make sure that VA follows the law. And it's very important to be prepared to go to court when necessary, just as this veteran had to do, because in this case, VA did not follow its regulation. And the accredited advocate in this case, which for the record was not CCK, was able to go to the court, do a very good job, and convince the 3 judges that decided this case that his reading of the regulation was correct and VA's was not, which is just vital to not only the veteran system, but to our country, frankly, is to have this series of checks and balances. And so the court is an important part of everything at VA, and we're certainly proud to represent a number of veterans there, and having an experienced advocate who's ready to go to that court can really, really, really be a huge benefit.
Are there any other particular circumstances where going to court is important? Say, for example, challenging a regulation, challenging a statute?
It has been important for the over 30 years now that the Court of Veterans Appeals has existed, and it's becoming, in my opinion, more important. Because as we said earlier when we were talking, the AMA, the Appeals Modernization Act, has made this process much more complicated. And it is so much more reliant on regulations and on the statutory framework that the United States Congress put out. It's very young. The Appeals Modernization Act is, in fact, very modern. And so the court really needs to make sure that VA is doing its job. And VA is doing what Congress told it to do. And there's really no way to do that except for to have an independent court oversee this process.
Yeah, Zach, I'm going to ask you one more question if I could. I know there's been a lot of Supreme Court precedent that's come out in the last couple of days here at the end of the term. In one particular case, overturned the Chevron Doctrine, which basically held that the courts, when they're interpreting regulations, had to defer to the agency, and that's now been overturned. What impact, if any, do you see in the veterans law in particular?
Well, Chevron has its place. This is administrative law, and so the Chevron Doctrine was an important part of this. To be clear, VA is still going to have some deference to its own regulations, but VA is not going to get deference in interpreting statutes that were laid down by the United States Congress. That is firmly the job now of the courts. And so, kind of to the point of what we're talking about today, the Court of Appeals for Veterans Claims and the Federal Circuit in particular, which oversees the VA system, are going to have a much more robust role to play going forward, because they are really going to have to roll up their sleeves and dig in and not just take what VA believes is a reasonable interpretation of statutes having to do with veterans benefits, but they're going to have to take a look at it themselves and offer an interpretation. So I think it's going to be slow. I don't think it's going to absolutely change anything overnight. I don't think it's going to be a seismic shift in the VA space. In other areas, I'm sure it will be. But it's going to be new, and it's going to be something that really highlights the importance of having attorneys and advocates who are accredited be able to take your case or find somebody who can to go to court if you need to do that.
So, Zach, court matters and experienced accredited advocates make a real difference. Congratulations to Mr. Williams and his counsel.